Welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. This series covers 4 fundamental questions, and today we are talking about the third question, using property. We come back around in today's video to the question of the Blackstonian bundle of sticks. One of those is the right to exclude others from using your property. If fee simple, as we've discussed it in other videos, were really absolute, you could exclude the whole world from using your property forever. But in reality, there are constraints on property owners' ability to exclude. Today, we are talking about exclusion from places we recognize as shared public places. Do people or governments who own these kinds of places have the right to exclude? Property law recognizes and protects public use in several different ways. One of the most important ways is the public trust doctrine. Okay, so where does the public trust doctrine come from? It is rooted in English law. It is going back farther in Roman law. It involves the public's right to use or access common resources like water and beachfront property. So this is an ancient doctrine that we've incorporated into modern laws. The public trust doctrine took hold in this country in the middle of the 19th century, but it wasn't until in 1892, a Supreme Court case, Illinois Central Railroad Company versus Illinois, that it was more deeply enshrined into our judicial canon. This is a great set of facts if you know Chicago. It involves the Chicago lakefront, which at the time was very rapidly developing. As that development was happening, Illinois Central starts to take more and more land, starts to build more and more tracks, and starts to build infrastructure along and into the river. The company undertook this development pursuant to a claim to riparian rights to develop into the lake bed. So part of the justification for its development was the legal property right that they claimed they had to develop some distance into the water itself. Now, this is a different dimension of riparian rights from the one we discussed in the video on riparian rights to water in watercourses, because here we're dealing with the lake bed itself. But they are both related in that they both deal with property rights that derive from the adjacency of land. In any event, it's not just riparian rights that Illinois Central is using to support its development. The company also received an explicit blessing from the state legislature, which passed the Lakefront Act. It granted the railroad a lot of power over development of the land and the harbor. Okay, so what does this Lakefront Act say? It places limitations on the use or transfer of the property if we get down to the details. It says, for example, that even though Illinois Central has some rights to build, they could not impair public rights of navigation. They could not obstruct the harbor and traffic in the harbor. They still had to pay standard rates for cargo. They had to give certain revenues to the state. They could not transfer title to the property to anyone else. So there are a number of limitations on Illinois Central's ability to develop into the lake bed, but beyond those limitations, they could build as many or as few docks and wharves as they saw fit. Looking at the Lakefront Act, the Illinois Attorney General in 1883 says, wait a minute, maybe this is too much power. There's a lot of economic rights that are entwined with the property rights that the legislature gave to the railroad. So the question for the AG is, can the legislature really give all of these rights to submerge lands to a private party? And again, the case makes it all the way to the Supreme Court. The court says, we know because we've developed talking about this public trust doctrine, the court says, no, the railroad cannot encroach to navigable waterways, into waterways that are meant for public passage and public use. The railroad can only develop the shoreline and areas close to the shore where they are not interfering with navigability. The court's opinion also says the state has no authority to give away the submerged lands because they are held in trust for the public. And so here you see the emergence of that doctrine. What has happened since Illinois Central? So since that case, the public trust doctrine has been extended by courts and argued to be extended further by scholars to include other natural resources. Environmentalists love the public trust doctrine because it's helpful for them to fight for environmental interests of all kinds, and it also embeds into the law human access to connection to nature. The public trust doctrine has also been used to justify public access to resources like beachfront property. And many people see it as an opportunity to help us protect our air, public parks, forests, wildlife, and other natural resources that may not be available without it. So that public trust doctrine has been questioned by some as being a made-up doctrine outside of the Constitution, outside of what outside of what critics would consider to be a traditional way of developing doctrine in the law. Putting those criticisms aside, however, the public trust doctrine has served an important purpose and will likely continue to do so in the years to come. I will leave it there. I look forward to engaging with you on social media, through my website. Please be in touch. I will look forward to seeing you soon. Thanks again.